Money9 Jhatpat brings in some bad news for taxpayers. The Supreme Court on Wednesday invoked its extraordinary powers under Article 142 of the Constitution to uphold all reassessment notices issued after March 31, 2021 by the Income Tax Department, reopening assessments going back 6 years. Nearly 90,000 reassessment notices that were issued by the Income Tax Department after April 1, 2021 under the provisions of the unamended Section 148 stay valid. Supreme Court on Wednesday ruled in favor of the Income Tax Department regarding the reassessment controversy. It held all notices issued under old Section 148 will be deemed to have been issued under Section 148A. This order by the Apex Court would mean that the change in law can't be an alibi for taxpayers to escape the proceedings initiated via the notices. The rare step taken by the Supreme Court invoking the Constitution will help clear the backlog of over 9,000 appeals filed by the Finance Ministry. The Apex Court ruled that its order shall also govern the relevant pending cases before various high courts. Earlier, the Allahabad, Bombay, Calcutta, Delhi and Rajasthan high courts had quashed these notices. Only the Chhattisgarh High Court was an exception as it had upheld issuance notices. The Apex Court bench composed of Justice M.R. Shah and Justice B.V. Nagaratna had reversed the orders passed by a multitude of high courts that had favoured the taxpayers. Remember, in the February 2021, the government cut this reopening period to 3 years with effect from April 1, 2021 to reduce litigation. But the department took the plea that since it extended date to June 30th due to COVID, the notices were issued after March 31, 2021. Now the IT department can go ahead with the reassessment proceedings, that is, opening up past cases. But the taxpayers will have recourse available under the amended law, which is the right to be heard. Section 148 of the IT Act granted the IT officers the power to reopen past tax assessments if they had a reason to believe that certain income had escaped assessment. But between April 1 and June 30, 2021, the IT officers issued reassessment notices under the old provision. It was challenged by taxpayers. Surprisingly, in Wednesday's order, the Supreme Court invoked the provisions of Article 142 of the Indian Constitution in a tax matter. The tax experts believe that thousands of pending and already quashed cases across the country will now be processed in terms of these directions. Hopefully, the IT department will conduct a fair inquiry and drop those notices which do not pass the test laid down by the new law. Keep watching Money9 for more such updates related to your pockets.